Hi, I'm Shashwat Sharma, a member of the International Tax and Fund Formation Practice Groups at Nishith Desai Associates. I'll be dealing with the impact of the Union Budget 2016 on the funds industry. I'll first start with the proposed changes to the tax regime governing alternative investment funds or AIFs. Last year, the Finance Act 2015 had introduced a new regime for the taxation of Category 1 and Category 2 AIFs. Under the existing regime, such AIFs have been accorded a tax pass-through status, and the income apart from business income earned by such AIFs are exempt from taxation at the level of the fund and are only taxed in the hands of the investor. However, a major operational hurdle in the form of withholding tax obligations under Section 194 LBB has been placed, which interferes with the pass-through status given to such AIFs. Section 194 LBB mandates that all distributions made by the AIF to its investors or any amount credited by the AIF to its investors shall be subject to a blanket withholding tax at the rate of 10% without accounting for exempt investors or exempt streams of income. There has been a consistent demand from the industry for rationalization of the withholding tax requirements to ensure that no deduction is made while distributing income to exempt investors or from exempt streams of income, and also to recognize the treaty benefits applicable to certain non-resident investors who come from jurisdictions which have a beneficial tax treaty with India. Recently, the report issued by the Alternative Investment Policy Advisory Committee, chaired by Mr. Narayan Murthy, also echoed this view. In view of this request, the budget proposes that when it comes to making distributions to non-resident investors, the withholding tax rates be made subject to the rates in force under the Income Tax Act or the applicable tax treaty, whichever is more beneficial to the investor. This is sure to encourage participation by foreign investors, including non-resident Indians, into AIFs, as this will allow investors resident in countries like Mauritius or Singapore, which have a beneficial tax treaty with India, to avail a nil or lower withholding tax rate. For resident investors, withholding tax will be continued to be deducted at the rate of 10%, and no provision has been made to account for exempt domestic investors or exempt streams of income. However, an amendment has been proposed which will allow the AIF to obtain a nil or lower withholding tax certificate for such investors or such streams of income. Also, there has been a consistent demand from the industry to accord a similar pass-through status to Category 3 AIFs. However, the Union Budget has made no provision to this effect. As a result, since such AIFs are usually formed in the form of trusts, they will continue to be taxed as per the provisions applicable for taxation of private trusts. Further, the budget does not provide any clarity with respect to the characterization of income of Category 3 AIFs. Due to the frequency in trading and complex investment strategies employed by such funds, the income earned by them runs the risk of being characterized as business income and not capital gains. This puts Category 3 AIFs at a disadvantage with respect to offshore funds with similar strategies. This is because of comparable offshore funds usually invest as foreign portfolio investors, and hence under the Income Tax Act, the assets held by them are deemed to be capital assets, and the gains arising from those such assets are held to be capital gains. Recently, there has been an attempt to harmonize the investment conditions relating to FPIs and AIFs, and this lack of pass-through status to Category 3 AIFs is thus a gap in the equal treatment between AIFs and FPIs. Last year, the Finance Act 2015 had introduced Section 9A in the Income Tax Act in order to incentivize fund management activity in India. The section provided that if certain conditions were fulfilled, the fund management activity would not amount to a business connection in India, and the fund would not be deemed to be a tax resident of India only because the fund manager was in India or the fund management activity was being connected in India. However, this regime failed to gain much traction with fund managers because the conditions provided were felt to be too onerous by the fund managers. The budget has sought to address some of these concerns by making two changes. Firstly, the requirement that the fund be a resident of a country or a specified territory with which India has a tax treaty under Section 90 has now been amended to require that the fund be established, incorporated or registered in such a country. This has been done because there are certain funds which have a corporate structure which does not qualify them as tax residents, such as US-based pension funds or Luxembourg-based SICAVs. Secondly, the condition that the fund not carry on or control and manage any business in India or from India has been restricted to require that the fund should not carry on or control and manage any business in India. While these relaxations are definitely commendable and go some way in addressing the concerns of fund managers of offshore funds, a few more changes, such as changes to the broad basing requirement currently in force, as well as the diversification of investments requirement, would have helped this scheme gain more traction with offshore fund managers. We now come to the proposed changes to the regime governing taxation of securitization trusts. In response to the consistent demands from the industry to make changes to the current tax regime, the budget proposes a host of changes which overhaul the entire Chapter 12EA of the Income Tax Act. One of the major criticisms of the current regime is that trusts set up by asset reconstruction companies formed for the purpose of the SAFESI Act are not included in the definition of securitization trust. The budget proposes to rectify this with effect from 1st June 2016. In a significant move, a tax pass-through status has also been accorded to securitization trusts, and the income distributed to investors or credited to investors of these trusts will be taxed in the hands of the investors in the same manner as if the investments had been made by the investors directly in the underlying assets. Further, the income in the hands of the investors will be deemed to be in the same nature and in the same proportion in which it was in the hands of the trust. In any given previous year, if the income of a securitization trust is not paid or credited to the investors, such income shall be deemed to have been credited to the investors on the last date of that previous year in the same proportion in which the investors would have been entitled to receive that income had it been paid in that previous year. The new pass-through framework also introduces a new section 194 LBC, which mandates that all income distributed or credited to investors of a securitization trust shall be subject to withholding tax. For domestic investors, if the investor is an individual or a Hindu undivided family, such withholding tax will be deducted at the rate of 25%. For other domestic investors, the withholding tax will be deducted at the rate of 30%. In a welcome step, for non-resident investors, such withholding tax will be subject to the rates given under the Income Tax Act along with the applicable tax treaty, whichever is more beneficial. Thus, investors from Mauritius or Singapore or countries with which India has a beneficial tax treaty will be able to claim treaty benefits. It is also pertinent to note that since a deemed credit of income is contemplated under this proposed regime, the withholding tax will be deducted even in those cases where income is not actually paid or credited to the investors, but even in those cases where it is only deemed to be credited. Also, it has been proposed that investors to a securitization trust should be allowed to obtain a lower or nil withholding tax certificate under Section 197 of the Act. Finally, we come to the changes made with respect to mutual funds. The Finance Act of 2015 had provided tax neutrality to a transfer by an investor of units in a mutual fund made under a process of consolidation of different schemes. The consolidation of different schemes are being encouraged so that different schemes with similar or identical features are consolidated in order to reduce the total number of schemes currently being offered in the market. It is felt that this will allow fund managers to focus on improving operational efficiency rather than focusing on marketing different schemes, and also allow investors to choose between different schemes based on investment objectives or investment strategy. In this regard, the budget proposes to extend this tax neutrality to also transfers made for consolidation of different plans within the same scheme of a mutual fund. This is a welcome step and would further lead to a consolidation and rationalization of different schemes of mutual funds and will help both fund managers and investors. Thank you. For more information, please do visit our knowledge site.